Right. Yes.
May the council approach the lies?
Yeah, please.
Your Honor, the Indian Constitution was designed to protect its citizens and promote equality towards everyone. Although it doesn't seem like it, as Mr. Kapoor is being denied his basic right to freedom. The appellant has been detained for a period of 14 years, which include being illegally detained for 5.5 years. His detainment after his acquittal is unjustified. He was also afflicted with mental abuse, which shouldn't be the case no matter what the crime he committed. This isn't the first case scenario where an Indian citizen was illegally detained. In Mr. Bhim Singh versus the state of Jammu and Kashmir, he was illegally prevented from attending the session of the Legislative Assembly. He was also inflicted with harassment by none other than the men in uniform who were meant to protect us, the police. The petitioner was also faced with a similar plight and was inflicted with mental abuse throughout his prison sentence. The jailer supervising reportedly states that the unlawful detention was due to the letter number 1838 on the 10th of May 1974 of the superintendent of the central jail to a district magistrate of Muzaffarpur, who sent the letter to the law department, which suggested that the appellant was unstable. This could easily be proven baseless, as there's no medical diagnosis or jail treatment which has a record to support their claim. In addition to this, based on a report on February 18 of 1977, the local civil surgeon claims that the appellant is normal and well, which was thereafter passed on to the law department on February 21st of 1977. Unfortunately, it seems that our country pays no heed to these cases as they continue to affect the citizens of the state. Another such case was the Esanand versus the state of Tamil Nadu, where he was not only detained illegally, but suffered bodily harm, torture, and to some degree was even humiliated in front of everyone present. This took place in the hands of, again, none other than the police, who are instituted to protect us. Under Section 30 of the Protection of the Human Rights Act of 1993, speedy trials are to be provided in case of violation of any human right. This was enforced in the above mentioned case and should be the same case over here too. These atrocities are committed towards us by the police is a serious misuse of power on their side and completely goes against the idea of protecting the Indian citizens. How are the citizens of our country meant to feel safe when the police itself are the ones putting us in danger? Another instance of this could be the Nirvati Bhera versus the state of Barisa, wherein Suman Bhera, the son of Nirvati, was taken into police custody, and the next day his body was found near the railway track. The lacerations of his body indicated towards an unnatural death. The decision in this case, therefore, made sure that the state could no longer escape liability in public law and had to be compelled to pay compensation when it committed such gross violation of one's fundamental rights, as well as the very basic human rights. It awarded a compensation of 1,50,000 to the petitioner. The Supreme Court also ordered the state of Orissa to initiate criminal proceedings against those who killed Suman. The appellant had been illegally detained and had to go a massive amount of humiliation and even severe depression, which is quite despondent to see. This is barely the loss he has faced. He's also faced he's also suffered from long-term causes of this, of losing personal connections, assets, and even jobs. The appellant may not be a perfectly righteous person, but that shouldn't matter, because even if he may be convicted of a crime, that doesn't give anyone excuse for to be subjected for physical detainment and mental torture. It would be considered a severe violation of right to freedom. So why should Mr. Kapoor be the only exception in this case? Our rights cannot be violated no matter who we are and what we do. Everyone should be treated the same. And as long as we are the citizens of India by the grace of our beloved Constitution. Therefore, I urge this court to take severe action on this horrendous act committed against Mr. Kapoor.
Fine. Now, second counsel portion, would you like to proceed?
I'm sorry, sir, I was facing audio problems.
No problem. Yeah. So would you like to...
May the council approach the dais?
Sure, please.
In Khatri versus State of Bihar, more popularly known as the Bhagalpur blindings case, a case in which the police blinded 31 individuals under trial by pouring acid into their eyes, the Supreme Court, for the very first time, was faced with a dilemma whether or not to award compensation for the violation of right to life and personal liberty guaranteed by Article 21. As proven and highlighted by my first speaker, Mr. Kapoor has been grossly violated of his fundamental rights, having been detained for 14 years after he was acquitted, something I feel we can all agree that no person should ever have to go through. Thankfully, the framers of our beautiful constitution created safeguards against the violation of the fundamental rights of the citizen. And this safeguard was Article 32, which contains the right to constitutional remedies. Article 32 is the very soul of our constitution and nation, as it ensures the protection of our fundamental rights and that the government does not violate or disrespect the fundamental rights of the citizen. The appellant, Mr. Kapoor, has filed this case under Article 32 in hopes of getting some compensation to continue his life like any other normal citizen. After being unlawfully detained for over 14 years, Mr. Kapoor has invariably been stripped of his very life and freedom. He has lost his job and all connections in and to the real world. The controversy or issue or question here is whether Article 32 provides monetary compensation for violation of Article 21. This brings us back to Khatri versus State of Bihar, where the Supreme Court faced a dilemma of whether to award compensation for violation of right to life and personal liberty guaranteed under Article 21 for the first time. It was observed by the bench headed by Justice Bhagwati that if compensation was not granted, Article 21 would be reduced to nullifying a mere rope of stand. The Bhagalpur blinding case made criminal jurisprudence history by becoming the first case in which the Supreme Court ordered compensation for violation of basic human rights. Mr. Kapoor has similarly been violated of his right to life and personal liberty, and he inevitably deserves medical treatment at government expense, ex gratia payment for his rehabilitation, and compensation for his illegal detention in jail for over 14 years. He cannot be expected to continue his life by simply being released from jail without any monetary relief for rehabilitation in order to at least have a semblance of a normal life. It is imperative to provide monetary relief to Mr. Kapoor as compensation for the violation of his fundamental rights. Not doing so will be doing mere lip service to his fundamental right to liberty, which the state government has so grossly violated. But Khatri versus State of Bihar was not the only instance where monetary compensation was provided for violation of Article 21. To provide further precedents where monetary compensation has been provided to people whose fundamental rights have been violated, in Sebastian M. Hongre versus Union of India, the Union of India was directed to pay an exemplary cost of 1 lakh rupees to each of the wives of persons on their presumed unnatural death. In Bhim Singh versus the state of Jammu and Kashmir, the Supreme Court had awarded compensation to the MLA petitioner for being illegally prevented by the state from attending the session of the Legislative Assembly. And in Saheli versus Union of India, damages had been awarded to the mother of the child against the Delhi administration and its police officers who had caused the death of the child. In state of Maharashtra versus Ravikant Patel, compensation was awarded for handcuffing and parading an under trial prisoner in a procession in streets during investigation. Thus, the principles of vicarious liability of the state were invoked in all of these cases. So if Mr. Kapoor has similarly been violated of his fundamental right by the state, why shouldn't he receive compensation? Why should we strip a man of his illusion and measure of getting some semblance of his life back after the absolute horrors that he's faced? Further, the respondent state in the jailer's affidavit has stated that Mr. Kapoor was released from jail upon his acquittal because he was reported to be insane, but has disclosed no data on the basis of which he was adjudged insane. Mr. Kapoor was apparently of unsound mind at the time of his acquittal, but this information was only communicated to the law department after about 6 years on May 10, 1974. And even after this, after another 3 years, when Mr. Kapoor was said to be normal by civil surgeon Muzaffarpur, the appellant was not released from jail for another 5 years. Further, the state has not provided any proof or statement regarding the specific measures taken to cure him of that affliction, and more importantly, whether it took 14 years to cure his mental imbalance. No medical opinion is produced in support of the diagnosis that he was insane, nor has any jail record been produced to show what kind of medical treatment was prescribed for and administered to him and for how long. The letter number 1838, dated May 10, 1974, which according to paragraph 3 of the affidavit was sent to the Law Department by Superintendent of the Central Jail Muzaffarpur, has not been presented before the court either. In addition to this, there is nothing to show that the practitioner was found insane on the very date of his acquittal. In light of the above mentioned fact, it is evident that there is no substantial basis whatsoever that Mr. Kapoor was of unsound mind. With this, having proven the necessity of this court to provide compensation to Mr. Kapoor for violation of his fundamental rights as a measure to impose state liability and ensure that such horrendous violations does not occur again, and having proven that there is no substantial evidence to prove that Mr. Kapoor was of unsound mind, the council rests her case.
Great. That's great. So, council person, would you like to come up again with a prayer?
Can I request the state government to grant the applicant with a monetary compensation for the extended imprisonment faced by the applicant, cover the medical expenses of the applicant for the abuses faced during the term, and provide an ex gratia payment for his rehabilitation process for the mental abuse as deemed fit by the court, keeping in mind the state of unemployment, no connection with the rest, illegally detained for over 14 years, and mentally deteriorated state of the appellant, and pass any other order that it deems fit in the interest of justice, equity, and good conscience, all of which is respectfully submitted.
Fine. Thanks so much. As we don't have an opponent here, so I do have a couple of questions here. So either of the council person can reply. Like, how much monetary compensation you want for your client? Because I've checked your memorial and can't find, you know, that monetary in terms of monetary.
Your Honor,
Yeah, please.
Your Honor, am I audible?
Yeah.
In most cases, we have mentioned in our memorial and even in our speeches, when we argued, we gave a lot of exemplars on how much the amount of monetary compensation given. Most of them range from about 30 to 1 lakh, 1,500,000. We are asking for a bare minimum of about 50,000.
So my question is here, like, do you think like 50,000 is enough? Is it going to help? 50,000 is going to help.
So we couldn't hear you before. We couldn't hear you before.
Council person, I just want to know, like, this amount is enough for your client, because 50,000, do you think like he can start any business or something like that in 15,000, that capital is enough for him?
Sir, we did not intend 15,000. We wanted 50,000, but that is our bare minimum. We are requesting for 50,000 to 1 lakh, the range between that. We want our amount to be ranging between 50,000 to 1 lakh, not 15,000. 50,000 is the bare which we are asking, the minimum amount of, but our range is from 50,000 to 1 lakh or even more. Since we have seen many exemplars of cases wherein this petition has been granted about 1,500,000 or even more than that.
The thing is that in India, if we talk about India, like 50,000 or 1 lakh is quite a small amount. if we'll talk about Indian currency.
So you're
So that's why I'm
you're
sorry.
not audible.
Okay. Is it audible now? Hello?
Yeah.
Is it audible? Okay, well, only thing is that in India, if you talk about the Indian currency, like, to start a good business, I think you should ask for bigger amount, but it's okay, no problem. Okay, another question I would like to ask you here, that's related to, okay, can you just tell me about, either of you can reply. What does it mean, habeas corpus?
Sir, is it possible if you could repeat your question?
Okay. I want to know, like, either of you can reply. Am I audible now? Hello?
Yes, sir, you're audible.
Okay, great. Can you just tell me the meaning of habeas corpus?
A habeas corpus petition is filed by a person in prison if they feel that their detention is unlawful.
That's right. Oh. Excellent. So having a body out of detention. Okay, fine. Okay, I know, like, you analyzed, you have done well research work, but I want to know, do you know anything about Article 329 of CRPC? Have you gone through this point while doing research work? I just want to know. Maybe researcher or maybe either of the council person.
Your Honor, our researcher isn't present with us today,
No,
unfortunately, due to certain circumstances. I hope I'm audible right now.
yeah, you're audible.
As far as I've understood the Article 329 of CRPC, I think the procedure is in case of a person of unsound mind is accused or tried in court, which is, of course, if they're proven to be of unsound mind. I believe that the fact that he is unsound would be taken into consideration, and he may be given a little bit more of an advantage, or maybe say he would be given a comparative advantage.
But also section 84 of the Indian Penal Code says that if the act of a person is done when he or she was of unsound mind, then it's not considered wrong.
Right. Quite impressive. Your research is not here, but your answer is correct. Only thing is that it is section 329. It's not article. Okay, that's good. Excellent. Okay. So either of the council person, can you just respond, like, how it is related to Article 21 of the Indian Constitution?
Article 21 guarantees the right to life and personal liberty, which when Mr. Kapoor has been unlawfully detained for 14 years, it is grossly violated.
Excellent. Okay, do you think, like, if there is any illegal detention, so that there is a violation of fundamental rights, so someone can only go to Supreme Court, or do we have any other provision in Indian Constitution by which they can approach to High Court?
There is a provision. There is a provision. It should be always tried at the lowest level of court for the case. So after this case, Mr. Kapoor can still approach any local court for getting monetary relief from the state government.
The question is, of course, when your fundamental right is violated, so as per Article 32, you can directly go to the Supreme Court, or someone can directly, go to the Supreme Court. Do you think, like, while doing your research work, I just want to know, like, do you have any idea, like, you came to know it's not only Supreme Court, they can also go to the High Court on some sort of provision which is given in Indian Constitution? A similar sort of article, like Article 32, directly you can go to the Supreme Court. So do you know any similar sort of article by which they can directly go to the, of course, someone has to start from the lower level, that is District Court, and then High Court.
Researching, we came across the Protection of Human Rights 1993, in which Section 30, it said that for the purpose of providing speedy trial of offences arising out of violation of human rights, the state government shall, with the concurrence of the Chief Justice of the High Court, by notification, set up for each district a special court to be a human rights court to try the said offences. I researched about the Protection of Human Rights 1993. I have mentioned it in the memorial too, but I don't think we found something specifically for High Court. Just
I would like to talk about this.
Would you like?
Fundamental rights is a huge thing in the Constitution of India. Even for India, it is a major thing which is necessary for each and every citizen, and it is important. India has taken notice of that and kept that in mind even while writing the Constitution. Article 32 under Part 3 of the Indian Constitution believes that Indian citizens can directly move to Supreme Court in case of any violation of fundamental rights, which shows how important the fundamental rights are for India.
So, fine. If we talk about India, like we do have our Supreme Court. And India is a very big country with a huge population, and sometimes it becomes, the process becomes very slow. So just for your knowledge sake, I want to tell you, or later you can utilize it, this point. So the similar sort of article that we do have is Article 226. So if you talk about Article 32, by which you can directly approach Supreme Court, and 226 is related to High Court. Okay, so maybe later you can just go through it. It's quite interesting, both the articles. That's what I just wanted to know. Quite similar. Great. So it was well researched, well presented. Your points are quite strong, impressive, and I can see, like, I'm really sorry, like, council person names are not mentioned here on first page. So maybe in second round, I'll request you to mention your name. And yeah.
Yes, sir, we'll do that.
And one more thing, like, I wanted you to ask for more compensation amount Because of
So that was actually because I had this doubt if we were going to be trying it as of present day or in the past. So according to that, 50,000 would be a huge amount,
that's
considering that in the actual
correct.
we got 30,000. So I was confused because in the past, if giving 50,000 rupees would be a huge amount of money, but today 50,000 is really small. And so I wasn't sure if we're trying it in today's present day or in the past.
Okay, no problem.
Additionally, we're also requesting for extra payments like rehabilitation and ex gratia. We are already covering that, and this amount would be a compensation for us. Of course, that is necessary for any personal amount, but 1 lakh is the highest amount of money we've received in any precedent given in the previous cases of those times. Clearly, now it is a lot comparatively a lot less, as my teammate has said. But I think that since we've already requested for a lot of payment, which is already covered by the government, we just thought it's that.
Yeah, no, I got your point now because sometimes it's difficult to go when I'm going through. So now I got your point. Like, yeah, of course, if you're talking about the past, it was a big amount. That's the first thing. And not only the monetary compensation, you want extra stuff for your client. That is also good. Maybe you could have asked for the government job, a government permanent job. Okay, that's also good. So that it's sometimes what happens that is in India. If someone was in jail, means people won't accept that person in society. Very less chance to get job. Maybe he can do some odd jobs or something like that. It happens. So that is another option that you should have added, but it's okay. Whatever you have done, it's really good. I really appreciate. Now, thanks so much. And now in next round, only thing is that you can mention like those who are the speakers, so they can mention their name. And yeah, now you have to prepare another memorial. In case if you have any kind of down, you can ask. No?
So that's just one more round, right? And then it's all.
Yeah, fine. So this time, the thing is that we try to keep it separate, and of course, like timings or the biggest issue. So in second round, again, you can decide like who will be the speaker and who will be the research or who is going to do
The
the
respondent,
yeah.
right?
Yeah.
Yeah.
And yeah, of course, I was quite impressed when I saw your memorial. Like you guys have done a great job, fantastic job. That's great. Thank you. So we'll meet once again whenever you guys are ready. Just let me know, and we'll arrange the session accordingly.
Sorry for postponing it so much. We both are in different curriculums. So when I don't have exams, she has exams. When she has exams, I don't. So it's really hard to coordinate it. Now we're both on winter vacation, so we can do it. Yeah.
No problem at all. No problem at all. The main intention is that you guys should learn. You should have knowledge about the Indian law.
It's been a great learning experience researching all the cases and the articles.
And if we talk about the Indian Constitution, is indeed awesome. Like so many countries, they don't have codified laws and they don't have constitution. Here, Indian Constitution is the lengthiest one in the world, and taken stuff from different countries so that we can serve the diversity that India has. So it's a mini world. Like if we talk about one Uttar Pradesh, one state which has more than Russian population. So now you can like entire Europe and half of the American. So to serve this diversity, this constitution is indeed superb. Great.
Yes.
So we'll meet once again in second round. Thank you so much. God bless you and good night.
Thank you, sir.